The next matter to come before the court this morning is State of Ohio versus Kathy Michnay. Both sides will have 15 minutes to argue. Appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning, and I can keep you apprised of the passage of time. The court has read the briefs, and we are ready to see when you are.
Thank you, Your Honor. May it please the court, my name is Russ Benson. I'm the attorney for the appellant, Joseph Patatus, in this matter. I'd like to reserve 3 minutes of my time for rebuttal. There are two substantive issues here and one procedural issue involved in this appeal. The substantive issues are, first, whether Mr. Patatus engaged in any conduct that was sanctionable under Civil Rule 11, which is the only basis for the court's decision, and what particular conduct, if any, was a violation of that rule. And the second substantive issue is what sanctions are allowable, what monetary sanctions are attributable to any conduct that he engaged in. The procedural issue is a simple one, and it complicates the resolution of the substantive issues, because the procedural issue is the court never held a hearing on any of this. We never held a hearing to determine whether Mr. Patatus's conduct was willful, and I would emphasize that under the law you need to show willfulness. As I indicated in the brief, this is a situation where you may have discourtesy, and I'll concede that. I think that Mr. Patatus could have notified counsel of the possibility of a plea resolution in the case. Of course, the resolution would not become final until the court accepted the plea, and sometimes courts in domestic violence cases, as this one was, can be reluctant to accept pleas. I've seen courts refuse to accept pleas, so this wasn't a situation where the plea had been accepted and finalized and everything done before they went out for that hearing. There was still the possibility that the court would reject the plea, in which case it would go ahead and hold a hearing on the motion to quash the subpoena. So there was no finality attributable to the plea at that point. But even assuming all of that, the fact is he was discourteous in not phone counsel and advising them of the possibility of the plea, maybe requesting that they move the motion to quash to a later date when it would be convenient for the court if the hearing were necessary. But we're not talking about Civil Rule 11 in the context of courtesy here. It does not punish negligence. It does not punish discourteous behavior. And that is basically what Dr. Burke is looking for here. He is claiming this man did not treat my attorney the way that I would hope that another attorney would treat her. And for that, he should pay monetary sanctions. And what you have basically is a presentation of the argument here that because Mr. Patatus didn't inform counsel of the possibility of a resolution of that morning, that he has to pay the attorney's fees incurred in. And not only just for the trip out to Cleveland, out to Stowe Municipal Court from Cleveland, the court attributes the entire costs that were allegedly incurred by defense counsel, by Dr. Burke's counsel in this, without any sort of hearing, and the court made a determination of reasonableness as to the amount of the attorney's fees, and I think they were reasonable. $180 an hour, so forth, for an attorney of Ms. Stone's experience and training is actually, that's more than fair. But the court didn't make any hearing, make any effort to determine what conduct of Mr. Patatus. Was it the filing of the original subpoena and the argument that, well, he did it in violation of HIPAA rules? Again, if you want to hold an attorney accountable for monetary sanctions every time there is a violation of the HIPAA rules, which, as I think I indicated in my brief, is like 122 separate sections, the courts are going to, well, other attorneys are going to be getting a lot of money. I don't think there's probably 10 attorneys that I know that fully understand the HIPAA regulations. And the issuance of the subpoena, again, under the law, that is not automatically exempt. Those records are not automatically exempt. If the court had ordered the production of the records, that constitutes an exception to the HIPAA rules requiring authorization of the patient. And again, that would have been determined had the plea not gone forward, had the case not been resolved when it was. This is an unfortunate situation because a lot of attorneys have spent a lot of time and a lot of effort that probably would not have been necessary that somebody picked up the phone. And I'm fully willing to accept the fact that Mr. Patatus should have done that. But we're not here to determine whether he was negligent. We're not here to determine whether he was discourteous. We're not here to determine whether he should have picked up the phone. We're here to determine whether he committed a willful violation of Civil Rule 11, what willful violation that was, and what sanctions should have been imposed upon him for that violation. And you have a court decision which does not address any of it, never addresses the willfulness issue. It basically buys into the argument that he was discourteous. There's no discussion in the court's order of willfulness, and of course the court never conducted a hearing to determine that, at which Mr. Patatus could have been to testify. He would have been examined as to his reasons for doing what he did, and the court could have made a determination of whether he acted willfully. The court could have then made a determination of what sanctions were attributable to whatever he did wrong that constituted willful misconduct. That didn't happen here. And I think that obviously the safe resolution of this would simply be to remand it back to the court for a hearing to determine those issues. But I think that the order of the court, since it does not even address the issue of willfulness, I think that you can find that this is not a willful violation. Nobody is really alleging that this was a willful violation. Under the court, Supreme Court decision in Dreamer versus Mason, Rule 11 requires dishonest purpose or some moral obliquity. It implies conscious doing of wrong. It means a breach of a known duty through some motive of interest or ill will. It partakes of the nature of fraud. It means with actual intent to mislead or deceive another. And the courts have consistently held that mere negligence does not fall within the auspices of the rule, is not punishable. That's what you have here, and I think this court should.
Remanded back for a hearing. Let me ask you a question. If this were remanded back for a hearing, what standing does Mr. Burke have?
Well, he's the movement. He's the movement, so theoretically he would have, I mean, this is the first. Well, and this is an odd appeal because none of the participants in this appeal are parties to the actual case. And I'm not, again, I want to emphasize, I think that's the minimum the court must do is to remand it back from a hearing. I don't think on the basis of this order, on the basis of this record, you can find anything, affirm any order of payment. But I think that on the basis of what you do have here, especially since the court has not made any, even addressed the issue of willfulness, and I don't think anybody argues that this was willful within the meaning of Rule 11, that the intentional intent to deceive, to perpetrate a fraud, I think that a simple reversal would be sufficient, but at the very minimum you need to remand it back for a hearing, but I would contend that reversal would be appropriate. If there are no further questions, I'll reserve the remainder of my time for rebuttal. Thank you.
Good morning, Your Honors. Hi, my name is Susan Stone, and I'm here for Dr. Burke, and thank you, Mr. Bensing, for your argument. This case is not just about not calling my office and telling us not to show up because the case settled. When an attorney files for attorney's fees under Rule 11, that is a very, very serious act that should not be done lightly. And I think what would benefit this court is a little bit of history. Dr. Burke's office received a subpoena ducis tecum for medical records on June 25th. The subpoena ducis tecum did not comply with Ohio Revised Code 2317.02 or HIPAA regulation 45 CFR 164.512. There was no release attached. My client said, oh, well, it's a subpoena, can I comply? And upon serious research, the case law is very clear that if especially a therapeutic provider turns over records that violates Ohio privilege laws and HIPAA, two things can happen to the medical provider. First thing is they can have their license suspended, and the second thing is they are actually liable to the patient for invasion of their privacy rights under the Ohio Code. The subpoena did not comply with the law for many respects. One, there was no release. Two, under HIPAA, you would, if you don't have a release and you can't get a release, you go to the court first and would have to give notice to the actual patient that you're going to the court so they could object to the subpoena, and you have to obtain a qualified protective order. As a courtesy, I picked up the phone, I called Mr. Patitucci's office and spoke to one of the attorneys there and said, hey, can you please withdraw your subpoena? It doesn't comply with Ohio law, it doesn't comply with HIPAA, and either go get a qualified protective order or provide me with a proper release. They were discourteous and would not respond to me. A week later, I was sent a release. When I looked at the release, it was actually not signed by Kylie Michnay, who was 18. She's about to turn 19, but it was signed by the mother. Now, this is particularly willful in this case because the underlying criminal action was a charge by Kylie Michnay against her mother for domestic violence against the patient. It was particularly suspect and concerning. Again, although, there was one other willful violation in that subpoena. Under Ohio law and HIPAA, you can only request that which is minimally necessary. So most subpoenas ask for treatment summaries. This asks for the entire file. And this is a person who has treated several years with Dr. Burke. Again, my client said, why do I have to be involved in this and incur legal fees? I said, you know what? I'll call. So again, I call Mr. Patitucci and say, please withdraw your subpoena. It doesn't comply with HIPAA. This is particularly egregious because you're now showing me a signature by the mother and the patient is 18. You can't do this. It doesn't comply with both Ohio law and HIPAA. Please withdraw your subpoena or you're going to force me to, I have no choice but to file a motion to quash. Mr. Patitucci would not withdraw the subpoena and told me that I was wrong.
Would a choice have been at that point to not comply with the subpoena and not file a motion to quash?
Well, so I researched that, and that puts you at a point where they can issue a motion for sanctions for failure to comply subpoena, and when I researched it, Your Honor, they said that the proper procedure when you don't agree with the subpoena is to file a motion to quash, if you want to do this correctly. I filed a motion to quash.
So backing up just a little bit, what section of the Ohio Code did Attorney Patitucci violate when he issued the subpoena?
2317.02, as well as the CFR 164.512E1.
Are those sections in the code which talk about violations that occur when medical records are released without the proper documentation?
It talks about privilege and how you get around privilege, and it's a very, the physician-patient and especially in the therapeutic, the case law talks about when there's a treating physician for mental health, that is particularly protected in Ohio, as you could well imagine mental health records must be.
Would the attorney representing the defendant in this particular case have been able to violate those statutes, not having those records in his possession to disclose improperly?
I'm sorry, I don't understand the question.
The attorney is requesting that he receive these records. And in order to do that, he had, at his behest, a subpoena was issued.
Correct.
Does the HIPAA law or the Ohio Revised Code say there's a violation of this statute if you don't include a release when you make a request by a subpoena?
The HIPAA law gives you several ways to avoid violating the law. There were many things he could have, many avenues. In this case, because it was a domestic violence situation of the mother charging the daughter, he could have come forward and say, I can't get a proper release. HIPAA would have allowed him to provide notice to Michnay and go to the court for a qualified protective order, and that would have been the proper procedure. Absent doing that, you violate HIPAA. And the case law in Ohio is clear and simple. It's pretty black letter that what he did was a violation of HIPAA. The procedures, there were many avenues, and I even said to his office, you don't even have to comb through the code. Google it, and it'll tell you how to properly comply with HIPAA. There are wonderful articles written really for people like Dr. Burke if they don't want to get an attorney to understand the law, and people who issue subpoenas. You can find it on Google. But be that as it may, I filed a motion to quash. He didn't oppose my motion, nor did he withdraw the subpoena. Then the court called me and said, because the court was even confused and it was suspect, that why would attorney for Kathy Michnay want to get the records of the minor after I filed the motion to quash, and called me in for a hearing. I called the court and I called, again, Mr. Patitucci's office. Please, why you didn't oppose my motion to quash, withdraw your subpoena or comply. I called the court. He didn't oppose my motion to quash. Why do I have to come down? Why is Dr. Burke always the one incurring fees? The court's staff attorney said, look, the Judge Coates is very concerned. Please come down. We prepare, we go down, we find out that the case had settled and no one contacted me. After 1, 2, 3, 4 times to avoid this situation, I file a motion for attorney's fees. He doesn't oppose the motion for attorney's fees. So Judge Coates issues an order granting me the fees. And by the way, respectfully, Mr. Bensing's wrong. I didn't charge for the whole thing. I think we sent a subpoena for the preparation and attendance of the hearing. It was $1,200. But the reason I filed that motion is at that point I was like, enough is enough. Every call, every attempt to make him comply, and 2 motions that go unopposed. It was only after the order he asked for reconsideration. So again, I have to oppose the motion for reconsideration, and Judge Coates did issue another order, which was much more extensive, Your Honor, basically saying that, noted that I called several times to try to get the withdrawal of the subpoena, noted that I called the court several times to avoid coming down, and that the subpoena was a clear violation of Ohio law, and that he should pay the $1,200. I knew it wasn't a lot of money, but it was to send a message. You can't practice law this way. That's why there is Rule 11. That's why this is beyond what is willful. This isn't a mere neglecting of picking up the phone. This started way before.
Was there another, I think there's some argument in your brief regarding another mechanism other than Rule 11 that the court may have granted these attorneys fees on?
Yes, there's case law basically saying that courts have the right to sanction attorneys. That's their inherent power to regulate the courtroom. I mean, judges can sanction attorneys for a whole host of matters. Judges have even ordered attorneys to spend a day in jail for being late to hearings. It's not done often. I think we have, fortunately, a very civil court that tries not to punish attorneys. But a court has to have the right as a sitting judge to sanction an attorney. Then, the parade of disrespect continues. We then hear that they're going to file an appeal. And again, I'm not receiving any note. I knew that they were going to appeal. I'm not receiving any information. We find out that we're not on the notice of appeal and that our name isn't on the docketing statement. And I filed a motion to dismiss the appeal again. Then this case is what I call a parade of horribles. And the fact is, Dr. Burke didn't have a dog in the show. He was not a party, he wasn't involved, and he is now forced to have an attorney every step of the way protect him from doing where he was at risk of being liable to Michnay and for violating HIPAA, and it could have just been done with a simple withdrawal of the subpoena. After counsel picks up the phone and gives you a courtesy and says, hey, And I didn't say it to be a know-it-all or to be rude. I said, your subpoena doesn't comply for 10 million reasons, not just the lack of a release. What it requested was against the law. The procedure, everything about the subpoena was defective. Fix it or withdraw it. And there were so many things to do, and refused every single time to fix it, return my calls. If this isn't willful, I don't know what is. If this isn't subjective, I don't know what would ever meet that definition. It is beyond discourtesy, and it is not the way we should practice law.
Let's clear up a couple of minor points here. First of all, the daughter was not turning 19. She had turned 18 4 days after the subpoena was initially issued. Second of all, yes, there are other remedies that the court has besides Civil Rule 11, but those are contempt of court. And that's what Ms. Stone mentioned, was blocking up an attorney for showing up late. That's done under the court's power to punish direct contempt of court. There is no allegation here of contempt of court. So the only remedy is Rule 11, and that requires a willful violation. So let's take this step by step here. Let's start with the issuance of the subpoena. And let's assume that after the subpoena was issued, Ms. Stone calls up Mr. Patatus and says, hey, listen, your subpoena is invalid. I want you to withdraw it. He says, oh, okay, I will. Obviously, there's no sanctions available for him merely issuing the subpoena. Then we go forward. He doesn't say, I'll withdraw it. He continues to maintain it. Because there's nothing willful about an attorney refusing to do what another attorney asks. That doesn't furnish a basis for willful misconduct in and of itself. So she files a motion to quash the subpoena. And a couple of days before the hearing on the motion to quash, Mr. Patatus calls her up and says, hey, listen, we've resolved the case. It's not necessary for you to come out. Do you think we'd be here? Of course we wouldn't be here. There'd been no willful misconduct up to that point. The only real misconduct Ms. Stone is urging, the only real misconduct that anybody is claiming happened isn't misconduct, isn't willful misconduct. It's Joe Patatus's discourtesy in not picking up the phone and calling her to tell her that the hearing had been, that the case had been resolved. And that's not willful misconduct. That is discourtesy, as she indicated. That's not sanctionable. And even if it were, I don't know what's attributable to that. She was awarded $1,772. Now, it doesn't take, and that's at $180 an hour, it doesn't take 10 hours to get from Cleveland to Stone Municipal Court, even if you throw in a few phone calls before that. So I don't know what is attributed. At the very most, the only willful misconduct here would be failing to call her, and notice the use of the word failing, which is discourtesy. Failing to call her and notify her that the case had been resolved through a plea.
What if I issued a subpoena for something I knew that I clearly would not ever have been entitled to? Was that willful misconduct under Rule 11? Just requesting it because I might get it, whether I'm entitled to it or not.
Well,
is that sanctionable?
First of all, you're making the assumption that Mr. Patatus knew that he wasn't going to get it. And again,
I'm asking you to make that assumption just for the sake of this question.
Okay.
I understand it's not the facts.
Yeah, that's one of the problems. If Mr. Patatus had gotten, they've been hearing and said, I didn't care, I was going to issue it, I didn't care whether it was valid or not, or I knew it wasn't valid, which isn't the facts here. I'm very reluctant to draw a rule that says when an attorney issues a subpoena, which turns out to be in violation of HIPAA regulations or the statute, that constitutes willful misconduct, which gets sanctioned under Rule 11. I think
I understand that's artfully phrased, but
you want to pin me down more,
no,
right?
I'm just asking the question. If you really did, if there's evidence or indication that you really did know that you're doing something by issuing that subpoena which is in violation of, no, which is requesting something to which you know you are not entitled.
Oh, I think that if you're making a general suggestion that if an attorney if you're posing a hypothetical that an attorney issues a subpoena knowing full well he has no basis for getting the information that he is seeking in the subpoena, then I think you could at least make an argument that that's willful misconduct.
Even though he might get it.
Even though he might get it. Well, see, that changes it too, because it's not up to him to determine the law here. You know, if the person wants to get, I mean, he has a duty to his client too, to get the information. And if he issues a subpoena, it's a difficult situation. I can see the bad faith argument here, but on the other hand, you know, if an objection is raised to it and he withdraws it, then I think that removes any willful misconduct.
And I need to tell you that you've reached the end of your full
Okay.
rebuttal time. Thank you both for your presentations this morning. We'll be taking that under advisement, issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website. Thank you.
Thank you.
Thank you.